of you that don't know me, I'm Wendy Linnell, and I'm the president of the Havurah Club, and we are sponsoring this event tonight. We're very happy to be doing so. So welcome, and those of you who might not be a member of the Havurah, and if you would like to join, Maxine back there talking to Helene, she's our membership vice president, so see her if you didn't already say yes, you'd like to know more about membership when you signed in. So we want to welcome you, and I'm going to turn this over to Barbara Miller, who coordinated and facilitated this program tonight, to introduce our guest speaker.
Good evening, everybody. I'd like to introduce our guest speaker, Richard Chatwin. Give a little bio. Richard Chatwin is a partner with the law firm of Gerard Cox Larson. He is a certified specialist with the State Bar of Nevada in elder law and is also the sole Nevada representative with the Special Needs Alliance, which is a national invitation-only group of attorneys focused on special needs issues. Mr. Chatwin is a certified elder law attorney with the National Elder Law Foundation, who works extensively with clients who need help with Social Security issues, Medicaid, and other governmental benefits, as well as special needs planning, estate planning, guardianship, and probate matters. And Mr. Chatwin received his BA from BYU and his MBA and JD from UNLV. Yay. And I will add that he is a very good teacher.
Thank you. Thank you, Barbara. Thank you. Okay, let me get a few housekeeping items out of the way. Number one, stay on the floor or go on the stage? Who says stage? Stay on the floor, okay. Number two, who did not get a handout? Okay, so we weigh, you guys all know I'm a lawyer, right? And you still came. All right, that's fine. Okay, so do you happen to have a pen or something with you? Like what I can do is I can give my email address. You can always send me an email and say, send me this presentation. I'm happy to do it. If you don't have that, maybe I can just pass it along and you guys can take care of that, Barbara? Okay, so Barbara, you can reach out to her and say, that weird lawyer who came the other day, I want his presentation, and she'll know what to do. Okay, so try not to stress over that issue. We're happy to give you the info. An e-blast, okay. All right, so hopefully that'll kind of settle that issue for those of you that didn't get one. I apologize, I just way underestimated. Again, I'm a lawyer, I didn't expect this, right? You know, we've earned our reputation. Okay, number three. A vote on the stage? What do you vote? You lost. Okay, well, I appreciate you voting though, I love it. Let's see here. Oh, number three, I apologize in the handout for the small print. All right, I had someone come up and point that out. He is 100% right. It is small, right? You get your magnifying glass out, it's small. Okay, so okay, I'm glad you can. I'm afraid for it. It's small for me. I had to balance out between having 500 slides with a few things on each slide because PowerPoint's just kind of picky that way versus let's show several things and talk about it without me thumbing through slides like crazy. So again, I can get it to you in digital format. I'm hoping the size here is a little bit better for you guys to kind of see. So, but I'm aware of that. I apologize if that's hard for you to read in front of you on the paper. Yeah, and then you can send it out and they can zoom in on the computer and maybe that'll help too. So anyway, I apologize for that. Number four, this is kind of a unique format. A lot of the opportunities I have to speak, I am given a really specific set of like, this is what we're gonna hear about. And I had some general guidance on, they took a poll in the group here and I heard some feedback. So I'm gonna cover that, but I'm open to questions. I can't promise you I have an answer for everything, but let me give you a little disclaimer. I have found in doing this over the years, and I know I look like I'm 12 when I shave, but I promise I've been doing this, I'm in the double digits as a lawyer, okay? But there's two types of questions. There is, we're on a topic about something and you want me to kind of flesh it out a little bit more to understand it or apply it to your situation, that's fine. The other question is, you've got a really specific probably fairly long fact pattern that you want me to hear about, and then give you an answer for some free legal advice. I have no problem doing that, but let's do it after and not have that long, drawn-out question scenario about something that's bugging you go right in the middle of this. I've got all night. My wife has said I don't have to come home till I'm done, even though she's got the kids. So I'll stay, and we can go through it. Come on over, and I'll stay as long as we need to for those longer issues. Okay? Deal? Okay, lastly, save me one cookie in the back. I just want one. Okay. All right, so the general flow for tonight, and again, if things come up, let's talk about it as long as it's within the realm of this, right? We're not going to start talking about heaven knows what outside of this, right? But we're going to start with some mistakes that I commonly see with estate planning. I'm guessing, I'm not going to take a poll, don't raise your hand, but I'm guessing a fairly large portion of you have done some sort of planning, powers of attorney, wills, trusts, whatever it may be, some shape or form of that. I see a lot of mistakes out of that. So what I'm going to do is I'm going to lay kind of a general foundation, so we're all on the same page with some basics on estate planning, and then I'm going to dive into some things that I see over and over again that I don't want you to do, okay? And we'll talk about it. And then we'll dive into some guardianship stuff. I know you guys are well-versed and have had people come in recent past to talk about the mess that has been the guardianship system over the last 5-10 years. I'm going to touch more on, I'll touch on the generals for just a second, but again, I'm going to talk about legislative changes. We had a whole new set of laws that went into effect, mostly on October 1st. I'll let you know kind of what's going on there, but if you have other questions related to guardianship as we go, let's dive into it and talk about it, okay? Lastly, the other cool topic that came up was DNRs and PULSE, Physician's Order for Life-Sustaining Treatment, and advanced directives. Let's talk about that a little bit as kind of the final thing. If other things come up that's related, let's dive into it, but keep in mind that differentiation between the different categories of questions, and just be mindful of other people here that are coming to listen. Okay, fair enough? Okay, cool. So let's talk basics of estate plan for a minute. There are a few different options for all of us of how our assets are going to pass to our loved ones when we all pass away. Okay? The first option that a ton of us have in this valley and in this country is we have done no plan whatsoever. Okay? When you have that as your plan, the state that you live in has already determined for you who your heirs are going to be. Every state in the nation has a set of laws on the books that if you pass away without doing a will, a trust, any other option to dictate for yourself where it's going, it's saying where it's going for you, okay? In order for it to get to those named heirs that are in the statute, it's got to go through the probate process. Who's dealt with probate here before? How fun was that? Isn't it terrible? Okay, the good news is probate is 100% avoidable, and you want to avoid it. The only people that win in a probate are the lawyers, I promise you, okay? You pay this much for your estate plan, you're going to pay that much for your probate every single time. And that goes for anything in the courts. Anything you have a judge involved, your budget's going to get blown, I promise, okay? So you have a probate problem when you have assets that are stuck in the name of someone who's passed away. If I have a house just in my name and I die tomorrow, I cannot come back from the grave and sign the papers to give it to my wife or my kids or wherever the heck I want it to go. I'm gone and it's stuck. I'm going to court. So when you're looking at everything that you own, you're evaluating how it's not going to be stuck, not just when you've passed away, but if you're married, when your spouse has passed away, okay? That's probate. We don't want anything stuck when we're dead. Okay, so the next way that people will leave stuff to their loved ones is they have a will only. Now, the common misconception is that a will avoids probate. It does not, okay? A will allows for you to say where it's going instead of the state laws that I just referred to. That's a plus, right? The legislature, at least in Nevada, has got it all messed up where your stuff's going. I promise you won't be happy with it. But a will doesn't avoid probate. It's still stuck in your name, okay? So I'm going to probate and I'm going to deal with it. But the will is going to dictate where it goes at the end of the day instead of the statute, all right? So then we have the trust involved. The trust allows for you to say where it's going, and it'll avoid probate if you retitle your assets so that the trust is the owner of the assets instead of you. okay? I'm surprised. I'll meet with people that have done plans, and they have no clue about this concept of funding your trust, as I'll call it. Okay, if you have a plan and this is news to you, I'm giving you a homework assignment tonight. You've got to fund your trust. You need to retitle assets, so instead of it being in your name, the trust owns it for you. It's a new member of your household that's going to own your stuff. Okay? If you don't remember anything else we talk about tonight, remember that one point. All right? Questions on that? Okay. Yes, ma'am. I'll reiterate the question here. Or are you going to do that? Okay. The question is what to put in the trust. Is that fair to say? What assets go in? Okay, so the general rule is everything. Okay? That's the general rule. The exceptions are IRAs and 401ks. Okay? By law, those have to stay in your name. So what do you use instead? You use the beneficiary designations. And if you have a beneficiary designation done properly, automatically the ownership changes when you pass away. Nothing's going to be stuck. Okay? Does that help? No? Tell me. You want that account owned by the trust. If it's a non-IRA, non-401k stock account, you put it in the trust. Bank accounts, real estate, business interests. How does it affect your selling and buying? Zero. If you have a now if you have a revocable trust, a typical trust I'm talking about to avoid probate, there are different flavors of trust. There's asset protection. There's trust to minimize estate taxes if you've got a ton of money. We're talking what I'll call a traditional, vanilla, revocable trust. I want it to go to my heirs. I don't want to have probate. Zero changes. There's zero restrictions with that trust. Doesn't change a thing. Yes, ma'am.
We're working with an estate planner who's setting up an IRA trust.
Yep.
There is such a thing.
Yes.
Okay.
Yep.
Just wanted
Those
to-
are great. Do you have young beneficiaries? Yes. Okay, that's where you use it. Perfect. Yep, that's legit. Okay, 1, 2, 3. Go. Yes, ma'am.
Where are you?
Talk about annuities. Correct, yeah. So an annuity falls into that. You can't retitle the annuity. You're going to use the beneficiary designation. I agree. Some annuities end at death, but if you have one that continues, I agree. That falls into that category of IRAs and 401ks. Okay, yes.
With private equity funds that have been set up and you've got 17 members in that private equity fund, how do you deal with that in trusts?
It depends on the terms of the fund. Sometimes you have to get permission from the other owners before you move it to the trust. Other times you don't, and you just unilaterally move your interest over. The others don't. It doesn't matter about the others.
Okay.
Depends on the terms and conditions of the setup.
Okay, thank you.
Okay, another question here.
For all the banks that refuse to let you put your accounts in a trust, is there anything to do besides the POD?
Yes, fire the bank. And listen, as a general rule, the bigger the bank, the more the headaches. It just is. I could name banks, all of them. I have threatened to sue in writing a whole bunch for clients over the years. It's rare, though, that they give you a hard time about putting your own account in your own trust. That's pretty wacky. Is it? Oh, the online banks are a different critter. On brick and mortar, that's rare. The online ones absolutely refuse to do it. I have no idea why. I think it's a bunch of baloney. Well, I've seen it many times. Say it again? No, yeah, not all of them, but many, many do. So maybe you two should talk if you found one. Okay, yes, sir. Yeah, so let me talk payable on death. His question is talking about transferring to heirs. So here's the other option if you're not going to do a trust, okay? I alluded to it with the IRAs and the 401ks, a beneficiary designation, okay? That's the equivalent of a payable on death. That allows for your assets to automatically transfer if you pass away, just like the name alludes, right? So here's what I tell clients. Depending on your situation, your assets, your estate plan, however you want to structure this thing, two things. You're looking at everything that you own, and it's either one of two situations. Number one, the asset is owned by your trust right now, okay? Number two is it's going to stay in your name for the rest of your life and you're utilizing a beneficiary designation upon death. If you don't have one of those two for everything that you own, you're asking for a probate, okay? Beneficiary or in the trust, that makes me happy. That makes sense? So it's a good question. That, again, if you don't remember anything else, that's the one thing. If you got a loose end, knock that out or probate's coming. Yes, sir.
There's a dollar limit, but is going into probate, is that still at 15,000?
Okay, so the question is there a dollar limit for probate? There are different categories of probates based on the net value of the total amount of assets that have to be probated. Not the total that you had at death, but what is stuck. So the lowest category, it used to be 15, it's now 25 if it's going to a non-spouse, and 100,000 if it's going to a spouse. So if you've got a loose end that you blew, you didn't get a savings account in there, and it's got 50,000 in it, but it's going to your wife, it's a simple process to transfer it. You go over that 25 for a non-spouse or over 100 for a spouse, and it gets much more complex, more costly. And the most complex one is 300,000 and above. Yes?
If we have a trust that was generated in another state,
Yep.
does it make sense if we do it in Nevada?
Okay, so the question is, I had a estate plan in another state. I live here in Nevada. What should I do? I get this a ton from Californians that are moving out here, right? There you go. Okay, like I've done this, right? Okay. What part of California?
Southern California.
Okay. Not like it matters. I was just curious. So. Okay, awesome. Beautiful area. What street? I'm not going to be that creepy about it. Come on. Okay, so what do we do if we come from another state? Number one, the law says if you did your estate plan correctly in California, Nevada has to honor it. Okay? So I tell clients, I think this is the honest answer, I'm not going to tell a client they have to. Okay? I do think it's a good idea, particularly with power of attorney documents. Your healthcare and your financial POA docs, those are extremely state specific. So the answer I give is, I think it's a good idea. You don't have to, and at the very least, seriously consider updating your healthcare and financial power of attorney to be Nevada. I'd say the majority of the time, most clients say, you know what, I'm in Nevada, heck with California, I want it changed over. So that's how I approach it. There may be other attorneys out there that say, no, you need to change it. That's probably more because of their personal preference than what the law is requiring. Okay? So good question. Okay, yes? Yep. Is it all covered? So the question is, your question is, okay, so let me make sure I understand your question. If you have an account and it's owned by a trust, or all the stocks and bonds and whatever in that account covered, and same question if you have a beneficiary designation. In the same issue, if it's an account that has a beneficiary designation, there's all the assets in that account covered. The answer is yes. If the account is titled, and you can tell by who it's mailed to, that's usually your indication. If it's mailed to the trust, then you probably got it right. That's your telltale sign. Okay, so yes, everything in that account is okay. Okay, so the last thing I'll point out is that bottom part of the slide. When is a bad idea to use beneficiary designations, okay? If any of your beneficiaries have serious disabilities, where they're receiving certain governmental benefits, a lot of these benefits programs are very sensitive to how much in income and assets you have. So if you're going to leave an amount of money to a child or a grandchild or another loved one who has serious disabilities, you really want to be careful about leaving it outright into their name. That can do more harm than good in a lot of cases. You can set it up as a win-win, but you need to use a trust to do it, okay? The other one I'll say is if you have, I'll call it irresponsible beneficiaries, right? If your child's marriage is very rocky and divorce could happen, if they're terrible with money and bankruptcy is always on the horizon, if they have other issues or they're getting sued, if there's a threat to the inheritance, sending it to them outright and putting it in their pockets probably doesn't make a lot of sense. So the cool thing you can do with a trust is you can name the child as a beneficiary, It's their money, but you have a trustee that's a gatekeeper to make sure they're not dumb with it, okay? And while it's in that trust and you have the gatekeeper in place, if any of these bad events pop up, the money is protected. Divorce, bankruptcy, lawsuits, so forth, okay? Once you put in the trust that they're entitled to it and it goes into their pocket, those protections go away. So you just have to look at the situation to determine how much control from the grave you want to have. You can only do that with a trust. Beneficiary designations and a will, you can't have that control from the grave. So the question is, should you have a secondary or a tertiary trustee named in place? I would say at the very least a secondary. Certainly if you can only come up with one and something happens to that one, you better call your lawyer quick and do something, right? And I have that. Sometimes people, when you're picking a trustee, my advice is put in who you trust, right? We're talking about trust, but I mean literally you think of the power that they have over this money that you're leaving to them, and what can you do about it? Nothing, right? You're either seriously disabled or you're dead, okay? So put in who you trust. Don't get caught up in the geography of the situation. You don't have to have someone that lives right here in town or super close by. If they're not going to do right by you and your wishes, I think that's a foolish choice. I don't care where they live. Put them in if they're going to do right by you, okay? But yes, if you can put in more than one, to go more to your question, absolutely. Now, you don't need 5. I always get a kick out of clients that want to give me a list of 6 people in a row they want to name, but 2 or 3, yeah, I love 2 at the minimum, okay? All right. Okay, what not to do? Let me cover this real quick. A common reaction to this probate discussion that we're having is, okay, I'll avoid probate. Number one, my spouse is on it, okay? Joint assets are not going to be probated if one of the joint owners passes away, right? This goes for your house, bank accounts, whatever. If you got 2 joint owners on it and one of them passes, the other one takes title automatic, right? What happens when the survivor dies? I go to probate, all right? So it's a Band-Aid. It doesn't fix a lot in the long run, okay? Number 2 is then the client's reaction sometimes is, I'll just put my kid on it. Then when both of us are dead, my kid will take the title and then he or she can deal with it. Okay, that does avoid probate. That is totally true. But what happens if that kid gets sued or has a divorce or goes bankrupt? Guess what gets tangled up in that mess? Your stuff, okay? I've seen it happen. It's not pretty, especially bankruptcy. Your stuff will be frozen for a while. Okay, so that's one big reason to do it. The other reason is, particularly with real estate, there are income tax benefits to letting your child inherit it instead of taking it as a joint owner. I'm not going to dive into this too deep. If any of you have a tax background, a stepped up tax basis, if that means anything to you, is only available if you're inheriting it, not if you put your kid on as a joint owner and they take it that way. So when they go to sell it, they're going to pay a ton more in capital gains tax potentially because you didn't let them inherit it instead of being a joint owner. Okay? So for taxes and liability reasons, I'm not a fan of adding your child or children on your accounts just to be able to be on there to help you or to avoid probate issues, okay? All right. So here's a full estate plan, 5 docs typically if you include the trust, the will, 2 powers of attorney, one for medical, one for financial, and then you have the physician's directive, okay? I put trust for most people because like we talked about, sometimes people will do the beneficiary designations. I'm not mad at you if you want to do it that way, all right? It'll get the job done. You got to be mindful of who your heirs are, and if a trust makes more sense, then it's worth doing. Okay, let's talk about mistakes. Yes, sir.
What's the difference between healthcare power of attorney and physician's directive?
Okay, the question is, what's the difference between a healthcare power of attorney and a physician's directive? What a good question. Nevada is kind of weird in this area of the law, okay? All right, let me ask a question. Who's done a healthcare power of attorney? Did any of you remember those 5 questions that were horribly worded and you had to read it 10 times to kind of get your head around? And you initial if you agree with it or check the box depending on the form or don't, right? So those choices in a traditional healthcare power of attorney deal with if you want life support removed, and there's one that addresses if you also are okay with a feeding tube being removed. The physician's directive also addresses feeding tube issues on the other end of do you even want it in the first place? Okay, so for some reason, Nevada legislature decided to statutorily separate out these two forms from each other to deal with a feeding tube issue on different sides. So we do it to cover our bases. Technically, if you just have the healthcare power, you'll probably be okay, but it's available, so why not take advantage of it? There was another gentleman. Let me go here and then here. Okay, what is a pour-over will? You can structure a will in two ways. Number one is, like we think about when we see the movies, right? They go and they do the reading of the will, which never happens, by the way, in real life. But the will just say, I leave my stuff to Johnny and Billy and Jenny and Carol, right? I directly leave it to beneficiaries in my will. Problem with that is I'm going to probate court to get it to them, but it'll get to them. A pour-over will has one beneficiary. It's your trust. Everything pours over into your trust. Okay, so the idea is, if my goal is with a client who's I'm helping with estate planning is while you're alive, get all your stuff put into your trust now so that you don't have a probate problem. But if you have a loose end or you ignore my advice to do the homework assignment, then your will is going to put it in the trust for you after you've passed away and I've done a probate. Does that make sense? So the difference is, who am I naming as a beneficiary? When it's a trust by itself, we call that a pour-over will because it's pouring over into your trust where you have all the terms and conditions for who's going to inherit. Good question. Okay, I saw another hand. Yes, sir. Yeah. Yep. Yeah. So if you are allowed to have multiple powers of attorney in multiple states, you can. The traditional thing that most of you have probably done when you signed your powers of attorney is it says somewhere probably early on, I revoke all the prior ones I ever signed. And I bet that's what yours said. So the last in time will win. We're going to talk more about that with DNRs in a little bit, okay? So probably your last one you signed in whatever state that was is the one that's in effect for you right now. But if you had the right language in it, you could have one in Minnesota and one in Colorado and one in Nevada all at the same time. So what do you do if you can't sign one yourself? If you don't have powers of attorney in place and you need help, traditionally you go to guardianship court. That's why the powers of attorney are so important. Like a trust avoids probate, powers of attorney avoid guardianship. Okay? Does that answer your question? Okay, right here.
Yeah, on that same line, what if you're taking a trip, you're in Mexico or someplace, and you get sick, you're terminally ill?
So what happens? So the question is, if you're on vacation somewhere and you get sick, what happens? So I recommend, and I think this is one of the things I'll put in here. So we'll jump the gun and address this one issue. I recommend, if you have a healthcare power of attorney, giving a copy to your primary care physician. Because if you're on vacation and you're in a hospital somewhere and your wife needs to do something about it, she can you're not going to travel to your estate planning docs. You'd be weird, right? We just don't do that, okay? So you're going to have either someone at home that's going to get a copy of it to the right person, or you're going to have your primary care doc's office, you're going to call and say, fax one over to here kind of thing, so that they can get a copy of it. Okay, good question. Now, let me say something about this. I am telling you the black letter law, right? I'm telling you what the law says if you were to go look this stuff up and read it. Does the hospital or the bank always follow the law? No, no way, okay? So there are always frustrations, much more on the financial side than on the healthcare side, right? So in your question about if I'm in a hospital in a faraway place, will you have issues? Probably not. I'd be surprised. That's rare. But if someone you love is named in a power of attorney and they need to go in and start paying your bills, will they have issues? Boy, there's a decent chance of that. So we're going to talk about how to minimize that in just a minute. Okay, I saw another hand. Yes, sir. How would you compare an offshore trust to a Nevada revocable trust? Did I get that right? They are night and day different. An offshore trust, we do those. They become more and more rare because Nevada has local asset protection laws and asset protection trusts that are kind of taking the place of it. When I do offshore trusts, I do them in the Cook Islands. They have a really cool jurisdiction for that. I would say 99.9% of this valley does not need an offshore trust at all. The differences are totally different and the reasons you do one. So the revocable trust, we're avoiding probate, we're leaving things to our heirs in an orderly fashion. The asset protection trust or the offshore trust, you're going to use to park away a nest egg because you're in a high-risk liability situation. Doctors, real estate developers do this a lot of times, construction people, other types of businesses. And the ideal would be is you're putting money away for a rainy day that if something goes bad, at least I've got some money sitting around, right? For most of us, insurance kind of protects for those liabilities. Your homeowner's policy, an umbrella policy, your car policy has those liability limits to where you don't need to go above and beyond that to do an offshore trust or an asset protection, typically. But good question. They're there and they have a purpose and we do them. Okay, yes ma'am. Yeah, so is an offshore trust outside the U.S.? Yes, by definition, it's a trust done in a jurisdiction not the U.S., a totally different country. So again, I do mine in the Cook Islands, down near, going to New Zealand, going out that way. Okay, let's keep going here. Common mistakes. What not to do. Okay, I alluded to this one just a minute ago. Almost all banks, in my experience, I'm not going to say universally, but my experience has been most banks will allow for you to take your own power of attorney into the branch and, for lack of a better way to put it, because they phrase it in different ways, pre-register your financial power of attorney, okay? You're going in and telling them, I've done this document, it's legitimate, and my child or my friend or my sibling or whoever you've got named in there has the authority to come in and use this if they someday walk in and need to help me, okay? If you do not do this, I'm telling you, I mentioned earlier, these big banks are on my garbage list, for lack of a way to put it, okay? Because they just routinely shoot down financial powers of attorney out of a fear that it's fraudulent. The irony of that is there was a whole slew of legislation done about 10 years ago to expressly protect banks and other financial institutions unless they have actual knowledge that the power of attorney being presented to them is bogus and fraudulent. They have to have actual knowledge. That's a high standard. They can accept it and have zero liability. It's right in black and white. But heaven help me if I can get them to even read it, let alone follow or care about that statute. Okay? So the best solution I've come up with is go pre-register the darn thing yourself with your branch. Okay? The big banks are especially guilty of this stuff, and you've got a higher likelihood of headaches. Okay? Please do this. Now, some branches or some banks, they may look at you like you have two heads. I'm not going to say this is a universal thing with all banks, but I have had many clients successfully do this in a wide variety of banks. The smaller banks, the more local, regional banks, and the credit unions, I have had much less headaches with when it comes to accepting these docs if your kids or whoever are stepping up to the plate because something happened and you guys need help. Okay? That's number one. That happens all the time. Go register your stuff. Number two, we already talked about, get a copy of your healthcare docs over to your primary care doc. Any other docs that you feel are relevant, unless you're just going to carry this stuff around in the event of emergency all the time. Don't do that. You'll be weird. Okay? All right. Number three is a living will lockbox. I bet there's been some discussions with that already when they had the guardianship talks, right? You can register stuff. Secretary of State has this digital repository that you can put not just a living will, but your guardianship nomination, if you filled out one of those forms, other important legal docs, and so that hospitals and other third parties can access them in the event of an emergency, okay? So check that out. It's through the Nevada Secretary of State. It's been around, I don't know, 7, 8 years or so. It's a pretty cool opportunity there to take advantage of. Okay, number 4, failing to do a legacy letter. All right, that's my phrase for this. Let me describe what I'm talking about. Picture, I don't know, picture your kids even, all right? But even someone more distant, this is a higher likelihood of happening. You suddenly have passed away. Your spouse has already passed away. And now the successor trustee is up. What in the world are they in charge of? What if they need to know your PIN numbers to shut off the utilities? What if they need to know the Wi-Fi at your house? What if they need to know passwords to get into email accounts? Okay? They need a roadmap to know what the heck they're stepping into. Okay? I call it a legacy letter. All right? And it's going to have a lot of sensitive stuff in it. All right? I keep mine rubber banded with my estate planning docs. And when my wife and I go out of town, I tell whoever's watching the kids, if we don't come back, here's where it is, have at it. And it's gonna lay out everything I own. It's gonna lay out all the passwords. If you have kids still in the house, I don't think we're too worried about that here, but it's gonna say stuff that we need to know about the kids, social security numbers and whatever, right? Do you kind of feel where I'm going with that? Take time. It's not just enough, in my opinion, to just list out the assets. That's a huge help because it's always a hard scavenger hunt for your loved ones to figure out through the mail and your boxes of stuff in the house, what in the world did you leave behind that you've got to manage, right? So at the minimum, put together a list of assets, but go beyond that. PIN numbers, passwords, other things that are really sensitive, but if you can't trust these people with that info, they shouldn't be your trustee, right? Okay? Questions on that? That's another really important one that most people are not doing. And I get your kids coming in to see me and they say, how in the heck do I know what I'm in charge of? And I say, good luck, go start with the mail. And watch for statements to come in and you'll start figuring out through the mail. Okay? Yes? Okay, so the question is, what do we do about safe deposit box? Oh yeah, so you're just saying as a PSA, I think I have that on here. There it is, second to last one, okay? So you read my mind. Let me talk about that real quick. We'll jump to that one, then I'll go back to the other one. Okay, let me do safe deposit boxes, then we'll jump on that one. That one's sticky. So hold on just a second. All right, let's talk lock boxes. I don't have any problem with them as long as you can't have your safe deposit box, and maybe there are banks that do this, but I have never seen it yet, that allow for your safe deposit box to be in your trust, like we've been talking about, have your trust be the owner. They're gonna require you as an individual to do it, in my experience, okay? Fine. So if you pass away, even if you've done your estate plan beautifully, you've got all your stuff in a trust like we've talked about, no probate, no worries. I still will have to go to court and get a special court order to force the bank to allow your new trustee access to that safe deposit box because you didn't add that trustee onto the safe deposit box account while you were alive. Some banks have the whole fingerprint thing. They're getting all fancy with it. Some just have to add your name onto like a register and then you come show your ID and sign and you've got the key. It's all over the place, but you've got to add them on as if you're like you have it now. If they don't have access like you do, they're not gonna have it after you pass. And I go to probate court to get an order. I'm not doing a probate, but I gotta get an order to give access. Okay, so that's a very good point. Okay, questions on that? Yeah. Sir.
Elaborate a little more about that. Would that be like having an account in a bank and put two names on it and they have the same access to that same deposit?
So the question is like just trying to flesh out how that works. So I'm not talking a checking account or a savings account, right? We're talking just the lockbox. It's a unique critter in the banking world compared to regular accounts. You're gonna go on and you're gonna go into the branch with the person. They generally have to be there in my experience. You can't have them be afar and do it. And you're gonna say, I wanna add my kid or my sibling or whoever it is. It's gonna be the same person that's your trustee on your trust or executor in your will. I wanna add them onto the account. And they're gonna sign up all the paperwork and they have full access to it just like you do. But again, if you can't trust them with that, they shouldn't be on your plan, right? But you've got to go through and add them on just like you got yourself added on. Otherwise, when you pass, no one has access to that until the judge tells the bank to. Okay? Yes? Yeah, so the question is, don't you also have to have the key? At the very least, you want them to know where the key is, right? So if you can't find the key, you drill. I've been a part of drillings over multiple times. It costs, depending on the bank, anywhere from $150 to $300 to drill. Yeah, it's not cheap and it takes a while to line it all up and you gotta have a locksmith come out and yeah, it's a pain in the neck. So yeah, you gotta know where the key is too. I don't know if banks will hand out a second key if you sign someone up. I think they usually give you one or two to start and that's it unless you pay. So anyway, I'm not exactly sure on that. Okay, now the other question was, say it one more time so I get it right. Just in general, okay, so the question is we have children from previous marriages, like how do we handle this from an estate planning point of view? Okay, all right. very carefully. Very carefully. And the reason is, it's very obvious, right? If you're married, it's a second marriage, and your husband passes away, you are now the evil stepmother in the way of the kid's inheritance, right? I have a case right now. This lovely woman, she's got to be about 87. She told me her age. She's in her at least 85. And the adult, second marriage, they've been married about 5 years or so. Just sweet Southern belle, okay? And her husband told her up and down that everything was fine. And unbeknownst to her, the adult son took dad over to the attorney's office a few different times. He subsequently died. And now she literally is getting nothing but $20,000. She had sold her house and was promised she could stay in that house, and the son is evicting her right now. So this is where we're going with it. It's very careful. Here's the best advice I can get, okay? And this goes to this last point of being stubborn, all right? There's other things I want to talk about, but being stubborn. We're all stubborn in some way, right? But this goes to this. Number one, you've got to have some real clear communication with your kids and vice versa. And you probably shouldn't be there if we're talking with your husband. Your husband on his own needs to go to his kids and deliver the news without evil stepmother being there. You know what I'm saying? But he's got to go and be real clear about, this is what I'm doing, and this is what I want, and this is the way it's going to be. The communication needs to go up a new level of clarity, and the last thing you want is a surprise after he's passed away that you've got to kind of deal with, okay? Number two, clarity with your lawyer is important, because just like this example, this sweet woman I'm dealing with, I question his mental capacity from some of the records I've seen, okay? So the son just kind of brought him along, and the attorney went along with it. If you go to your lawyer ahead of time and say, these are my wishes, and if I get drug along by one of my kids and it's contrary to that, then that's a red flag, and you should not do it. And you need to give your attorney some specific instructions to not let your kids run roughshod over your spouse, okay? Now, how to structure, what are you leaving to the kids and what are you leaving to your spouse? You can do different things. I mean, one of the cool things with a trust is you can keep the house, for example, in the trust, let your spouse live there for the rest of his or her life, and then the house can still go on to the kids. You don't have to put it in the spouse's name and let them take it away from your kids, if you want to look at it that way. There's ways you can have your cake and eat it too. And there's a lot of detail you got to dive into that. But there's a lot of tricky issues with it. And if you have a lawyer who's less than ethical, like in this case, where the lawyer did some weird stuff just because the son said to, not his client, dad, probably. I'm a little biased because I'm on the other side, right? But this kind of stuff happens all the time. So lots of communication and lots of clarity between the lawyer and the family is the best prevention I guess I can recommend. But that's tough. That's tough. A lot of you might be in that boat. Be careful. And don't let someone do anything against your wishes. Does that help at all? Kind of? The devil's in the details of how you draft the trust, too. If you draft the trust with some different provisions, protections in it, that's going to help you get ahead of. Now, but let's go back to the being stubborn. We all want to stay in control of our stuff. We all want to stay in control of our life, right? But there are diminishing returns at a certain point that I have found to where if you are struggling with capacity issues, you've been diagnosed with a memory loss and Alzheimer's and dementia. Right now, you're probably still doing okay, right? You're in the early stages of it. But you need to think ahead and be proactive to protect yourself against being drug over to your lawyer's office by your adult child and messing over your spouse, okay? You've got to, as neutrally as you can, evaluate your situation and be willing to turn some authority over to someone that you trust so that you don't have bad things happen to you later. Sometimes by adult kids, sometimes by third parties. All right, I've seen a lot of bad stuff out there, and it's a lot of times because someone didn't reach out and get the help put into their life ahead of time before they really fell into a position where they couldn't appreciate where they were at, and they think they're fine, and they're not, okay? Walking down to the bank every day and maxing out your ATM and handing it to random strangers as you walk back home every single day until some person figures out you're doing this every day and starts stealing your money, that's not okay, okay? And that's someone who just held on for too long, okay? So that's part of the stubborn thing. Got to be careful. It's hard. I'm not saying it's an easy thing, but I have a lot of children call and say, oh, Dad is doing this crazy stuff. All the accounts are in his name. He won't let us help him with anything. And what do? That's hard. That's hard. And they're trying to help you. Let them help you if you get into a pickle, okay? You got to see that pickle coming as best you can. Sometimes that's not always possible. Okay, whoops. Let me address that second point real quick. We don't have a whole lot more time. Let me address this, and then we'll jump over. I think you guys are pretty well versed in the guardianship stuff, so we'll jump over to like the DNR kind of discussion. Is that okay with everyone? Okay. No? Yeah. Okay, so I'll touch on it just for a second here. Yeah, there's a lot that we could go into. We could spend a couple hours just on that. We won't do that, but I'll dive into it. Okay, I like your bravery for saying no. I like it. Okay, putting too many people in charge at once. You may have 2 kids, and you love them both, and they both seem responsible, but I cannot tell you how much money I have made as a lawyer because your children start picking fights when you pass away, okay? Even if you're alive, I have a case that's been going on, I don't know, 7, 8 years, where mom put daughter on the healthcare side and son on the money side, and they hate each other's guts, okay? The lawyers are the only ones winning. We have been paid 6 figures in fees over the years on that case because son and daughter are insanely crazy against each other. Mom loses, okay? So my general rule is I like one chief, not multiple chiefs, okay? You can put multiples on and it'll work, but you are running a risk of headaches, okay? And your heirs, and even you if you're alive, are going to lose because they start picking a fight and they're dumb, okay? So that's my advice on that. Okay, let me touch on guardianship for a second. I said it before, let me say it again. The general rule is you do not need a guardian if you have done a healthcare power of attorney and a financial power of attorney. The whole idea with a guardianship is that you are in a physical or mental situation that you cannot take care of yourself anymore, and someone needs to step in. Well, if you haven't done powers of attorney, no one has the legal authority to do anything for you, okay? So that's where those powers of attorney come into place if you have them. Otherwise, a judge is going to get involved in your life. Like I said earlier, anything with a judge is expensive and a pain in the neck, okay? Probate, guardianship, other litigation, you do not want a judge in your life for anything. So talking about the crookedness and the issues there, there's so much I could say. A lot of the problems were generated by the fact that the law in Nevada used to be that if you needed a guardian and your kids lived outside the state of Nevada, you had to associate with a Nevada resident to get the guardianship. So there were professional guardians that cropped up in the community to satisfy the residency requirement that the law had. 2 really bad apples and a few of their associates went way overboard. That's not even the right phrasing for it. Just straight crooks. And they are in jail. And they're going to be there for decades. Stealing, abusing, neglecting, horrible, horrible, horrible things. All terrible and wrong. So the law got revamped. It's been revamped 3 significant times in the last 5, 6 years. And number 1, that residency requirement is gone. Your kids can live in Timbuktu and be your guardian in Nevada, okay? I don't care what country, I don't care what state, they can be guardian without associating with a local resident, okay? So we chuck out the professional guardians to reduce that risk. Number 2, we now have required, anytime a guardianship case is filed in Nevada, a free lawyer is appointed to represent the person who is potentially placed under a guardianship. In Southern Nevada, it's through the Legal Aid Center of Southern Nevada, LACSN, L-A-C-S-N. Their whole job is to be your voice and your eyes. And every single case, they're appointed without fail now. So now, before, you had no lawyer. You were the only one that didn't have a voice in the action, and you're the one being placed under guardianship. So they turned that upside down and they fixed it. That's a good thing, okay? Number 3, there is significant oversight now on the financial management of guardianships. There are people that are hired now in the state of Nevada and at a county level that all they do for a job is scrutinize accountings that are filed in guardianship cases. And they are not shy of calling anyone on the carpet if they feel like there's mismanagement. So, were there problems? Yeah, there were some terrible bad apples. April Parks is public enemy number 1 in this arena, okay? Horrible stuff. But there have been some significant changes to where, you know, that happening, I'm not going to say it's impossible, but it's significantly reduced, okay? Does that help? That's an elevator version. Correct. Yeah. If you have powers of attorney from another state, I can use them. I've used them before in the past. Yeah. If you come and see me and you've got something from Maine, I'm going to tell your family, don't go to guardianship court. Now, here's the problem, though. If you have powers of attorney and they get denied by a bank, what can I do? I got to go to court, right? They got shot down. All the more reason to go pre-register, as I say, your financial POAs to try to eliminate that risk. It can happen on the healthcare side. That's really rare, especially if you have a spouse. Yes, ma'am. Yes.
Are you familiar with, and can you share with the audience if you are, the guardianship nomination forms that must be filed by everybody and put into the Secretary of State's lockbox?
Sure. Yeah. I think you guys had someone come out and kind of address this quite a bit recently. Yeah. So go ahead. Yeah.
I thought I heard you say that if you had a POA and something else, that was enough. So I wanted to back up and say that that isn't enough.
Okay, so the question, for those of you who couldn't quite hear, is she's addressing a form. It's called a guardianship nomination form. And it's a standalone document separate from powers of attorney, okay? It's important to do, absolutely. Can you avoid a guardianship without it? Yes. But is it better to have it? Yes. Okay? So the ideal situation would be is to do the form and put it in that living will lockbox, for those of you that didn't hear that. That's one of the primary purposes for that. That and the healthcare power, the 2 major docs, I would put in that living will lockbox. So, but can you avoid a guardianship without it? Yeah, you totally can. Now here's where, instead of the standalone form, here's what a lot of attorneys do, and here's where you can look for it as an alternative. The laws for how powers of attorney were drafted changed about 4 years ago, 3 years ago. And now it's not required, but it's strongly recommended by the legislature, the way they did it, that you can put the nomination as a clause in your financial and your healthcare power as an alternative. Okay, so at the very least, hopefully you address it in your power of attorney, but even if you do, you can do the separate document, and at least one of those 2 you should have in some shape or form. Does that make sense? You're looking at me like I'm lying. Talk to me. Okay. I'm okay. I'm all ears to hear about it. Okay. Well, if I'm all ears, but like, so I just want to say, like, yeah. Mm-hmm. Uh-huh.
Smith is being heard in court at 10 a.m.
Yep.
11 a.m. The job of the court is to check that lockbox and make sure you don't have a guardianship nomination.
Right.
And then they can't hear your case.
Right.
It's going to find your trust with that section in it.
So the question, the issue is if you do the lockbox, the judge before your hearing should look and see if you have anything in there, right? I totally agree. Now, whether the judges are actually doing that, we've got 3 adult guardianship judges. Right. Hopefully they're doing that. I have seen a few where it didn't get brought to light until after, so it's not perfect. But what's the best you can do? You do the form, put it in the living will lockbox, and I'm still a fan, along with it, of putting it in the powers of attorney with it. Because one of those 2 you're going to probably catch, right? But yes, that form is awesome. I totally agree. So good point. It's called a guardianship nomination form. I haven't looked, but maybe you know. Is it, if you Google it, I bet Nevada guardianship nomination form, it'll pop up. Yeah. Secretary of State's website, they have that form. I'd recommend getting it notarized. It's not a requirement, but that proves you signed it instead of somebody else, so that's always a plus. Okay. Well, Okay, I have to go back and look at the form. Okay, there's nothing wrong with that. I'm always a fan. The whole idea of a notarization is to prove it was you, not somebody else signing it, right? So that's a plus. Yes, ma'am. And we got a few minutes here, so I'm going to hustle after this. Yeah. Yes, so that's a great point. So the question is, I said, why don't you go pre-register your financial power of attorney, your trust, whatever financial docs, go pre-register them with your bank. But it goes beyond that, right? Merrill Lynch, TD Ameritrade, right? Yeah. Oh, yeah, I'm a fan of getting it all out there because, number one, you're going to reduce some fraud potentially from happening. And number two, you're going to reduce the chances of it getting rejected. So yes, thank you for expanding that. I totally agree with that statement. Yes, sir. Yes. Yep. Yeah, Mr. Graham. Yep. So the question is, how do you make, okay, so who knows who Rob Graham is? Okay, you remember his commercials on TV? He was on every 5 seconds advertising estate plans. Real calm, he's a nice guy if you met him personally, okay? But Rob, the number, gosh, $10 to $13 million or so they think he stole from clients in the client trust accounts. He is now in prison. So the question is, how do you avoid being swindled? So the purpose of an attorney-client trust account is to hold money for a temporary purpose. I'll give you an example. I had clients who were inheriting a whole lot of money, and they owed the IRS as part of a death tax $11 million. Okay? They ran that through my trust account, and I paid the IRS instead of them. So if the IRS thought they owed more money, they wouldn't know where they bank. They'd have my check and not theirs, right? So they gave me $11 million, and I sent a check to the IRS with the money after it got deposited in my client trust account. There's other purposes for it. It happens in probate from time to time. In probates, in guardianships, sometimes, but not so much, a lot in probate, you have a requirement where either you're going to get a blocked account or you're going to get a bond in a lot of these cases, okay? A blocked account in some attorneys' minds means the only option is you put it in their attorney-client trust account. You don't have to. It can be in Wells Fargo or B of A or whatever and just blocked, meaning you can't touch the money until a court authorizes you to do so. An attorney-client trust account, it should not be touched until the court tells me as a lawyer what to do with it, but I can still go as an attorney and take the money. That's what Rob Graham was doing. He was losing money left and right. He was advertising like he was a personal injury attorney, but us estate planning attorneys don't make nearly as much as personal injury attorneys do, so he wasn't getting enough money back on his investment, and he was losing like crazy, and he kept the ship afloat through that. So number one is if you want to block your money, do it outside of the attorney and go to a bank and block it. Number two is if you have a settlement coming, sometimes the settlement money will go into the lawyer's account. It doesn't have to. Their lawyer will like to do that because they want to make sure they're going to get paid, but they can just have a portion that they're owed get sent to them and the rest go to you, right? So you can use those sparingly. The lawyer may say it's the be-all, end-all. They're used all the time and they're very important and they get audited quite a bit. They're not just out there in the wind. The state bar looks at them a ton, but they don't have to be used as frequently as some lawyers may make it feel like you have to. Does that help at all? Okay. Yes. Is your estate plan ever too old? Is that what you're saying? I saw one the other day. It was from the 50s. I saw a trust from Massachusetts done in 55, and I was like, wow, that trust is still valid. No, that's something different. So the problem wasn't the age. The problem was you didn't have the original document. That's weird. There's more to it than that. We'd have to, New York, heaven knows. Heaven knows. I thought you were talking here. You're messing with me. In New York, who knows? There may be a statute. Maybe it gets in Nevada. Heck no. You know, it can be from the 19. No, yeah, don't worry about that in Nevada. Okay, let me cover the DNR for just a minute, okay? We're running long on time. Let me do about 5 more minutes. Everyone hang tough. You're all still awake. That's what I'm really happy about. I like it. Okay. All right, hold on here. Guardianship. Okay, so I'll send you these slides. You can see the changes. The changes have been really significant in the past. They made some more now. Some good stuff, not nearly as revamped as the prior version from the legislature a couple years ago, but still, they're making some good progress. Okay, DNR versus PULSed. Who's heard of a PULSed? Isn't that a funny acronym? Okay. What in the world are we talking about? And then there's the living will, or the physician's directive. I'll throw that into the mix also, okay? So we got kind of 3 docs. They're all dealing with end-of-life issues, okay? But there's some differences to them. Yeah, so I have in the handouts, for those of you that have it, a sample PULSed and a sample DNR. So you can kind of get a flavor for what they look like in Nevada, okay? Number 1, a DNR is extremely narrow. Just like the name it says, right? Do not resuscitate. The whole point of that document is if you would normally require some sort of means to bring you back, you're not breathing and so forth, don't do it, right? You've got a terminal condition. There are specific statutes on when these DNRs can be used, and you have to have a serious end-of-life issue, okay? And I can't remember the exact number of months. I don't think I put it up there. I want to say it's that doctor's opinion within 12 months that you may or may not survive. Yes, sir? The doctor. A DNR and a PULSed. The question was, who defines serious illness? The doctor. The DNR and the PULSed are not signed by you. They are signed by your physician after consulting with you. Okay? So let me give you some ground rules for these things. Number 1, as long as you are alive and able to give your wishes, that's what's going to govern. Okay? Even if all this stuff's been signed for you, if you can still give your wishes on how your medical treatments should be handled, the law says defer to that, right? That makes sense. So we're not going to handcuff you because you got this form on file if you feel differently on a given day or circumstance, okay? Number 2, if you look at the PULSed form, and you can Google this stuff online if you want to pull these forms up, they're available. The PULSed covers everything the DNR does plus, and it covers a whole bunch more stuff. So I've got a photo of it. I don't expect you to be able to read it. But there's just all sorts of stuff in there, plus, and this B part is basically that's the DNR there, and then here's the PULSed. And it covers just a bunch of different categories, right? So if you're going to pick between a couple of them, do the PULSed. It's going to do the DNR plus a bunch more, all right? Number 3, for the living will, there's a lot of crossover with all these docs, okay? They're not for isolated, separate incidents. They all have a lot of overlap, all right? So Nevada addresses that issue. Okay, we got let's say you do all 3 of them. Okay, what happens? Number 1, if there's a conflict in what you've put in your wishes between a DNR, a PULSed, or a physician's directive, or a living will, as I'll call it, okay? If there's a conflict, the last in time wins. And that's the general rule of law with your estate planning docs. If you do multiple version thing, the last in time wins. That's always your starting point, okay? Number 2, if they don't conflict with each other, then use them to the best that you can. Work with them, okay? If they're working with each other to give you a comprehensive view on what your wishes are going to be in different circumstances, great. We don't have to pick one or the other, okay? You can see the statute here. You can look it up for yourself there in chapter 449A. All right, so the physician's directive, you sign. It's only going to be effective if you can't make your own decisions. The DNR and PULSed, doc is going to sign, and he or she has to have the opinion that you have a very short lifespan due to serious issues you're facing. And it's only going to kick in if you can't make your own decisions. Okay? So, don't worry about it unless you've got some real serious issues there. Questions about that? That's a real quick and dirty, we got questions. Okay, yes? Yeah. You didn't get to the point in your life. Yeah, so the question is, if you don't have a PULSed, right? Yeah. Okay, so the question is, if I just have a physician's directive, or I'll throw in there a healthcare power of attorney, and I never got to the pollster or the DNR because I'm doing okay, and all of a sudden something happens, right? That happens, very common. What happens? The law says they should, if you can't give your own direction on what's going to happen for your medical care, whoever you've named as an agent in your healthcare power of attorney has the authority, okay? That's what should happen, all right? Remember I told you, law versus reality. Okay, let me tell you the law versus reality on another related matter. The law says that if you do not have a healthcare power and you have a spouse, that spouse only has a legal right to make decisions for you if it's an end-of-life situation. That's what the statute says. What's reality? If you have a spouse, are the medical people going to listen to him? Yeah, they're going to listen to him every time, okay? They shouldn't if they follow the law, but they do, okay? I'm not telling you that to make you feel better about not having a health care power. You better go and do that if you haven't. But the reality is that they're going to be a little more relaxed to that, particularly with a spouse, sometimes even with adult children, okay? But again, you got to be careful of that. So, but the agent in your power of attorney, their job, there's those funny worded 5 statements that you had to initial or not initial in a healthcare power. The whole idea with that is to give parameters and guidance to your agent who you've named in there to make decisions and to look at the circumstances and what you put in the wishes and kind of jumble all that together and make a choice. Okay, you're not signing your death warrant when you do a healthcare power and those funny wishes that are in there. Okay, you're just giving flexibility or taking it away based on how you feel. Okay, we got a couple questions and I think we're going to be done. So I've got 1, 2, 3. So we'll start in the back. No, this is a Nevada specific. So the question was, this is for all the U.S. or not? This is a Nevada specific statute. And I apologize, that NRS in the front of it stands for Nevada Revised Statutes. If you get sick in another state, you are subject to that state's laws. And they may or may not jive with what we got going on here. But is this common? I don't think we're a big outlier with how this works. The risk you may have is there may not be a statute that addresses the situation. That's more common. I could see that being more common than having something that's totally opposite of this. This is pretty common sense. If I were to do a 50-state survey, I bet this comes up quite a bit. Okay, 2 more hands I saw. Barbara, you want to go?
Yeah, is there any difference if something happens and you call the paramedics? Is it true? There was a discussion that we had that they can, even if you have a DNR, they still say they have to resuscitate you?
Yeah, so here's my general rule on that. I had a friend die last week of cancer, okay? He had a DNR. He was 43. And the rule was, if he has something happen, don't call 911. And he passed a week ago, and they didn't call 911, and that was his wish. He was. Is it required by law? What? I'd have to. So the question is the law that if you call 911, the paramedics are required. I'd have to go back and double check the statute. My understanding is the answer is yes, they are required. Yeah. So that's why we do not call 911 if we have a true DNR hospice kind of situation. Yes. Here.
I have a relative who lives in Maryland who has a very ill husband, and she has a post form, and she can hand it to the, the emergency medical, and then they do not resuscitate. But that doesn't that's not the case in Nevada?
Here's my counter. My counter is, why would you call 911 in the first place then, right? Does that make sense to you? Like you shouldn't call them. You don't need them anyway, because why call them and then say don't do anything? You know what I'm saying? That's what's going on there. Okay, I saw 1 or 2 more hands. Let's go real quick. Yes, ma'am? A Connecticut, New York power of attorney. Okay, yep. And she's dying here.
They had asked me, they had a palliative team come in and talk to me about what they thought I should do.
Yep.
And that, it was basically quality of life versus quantity of life.
Yep.
She would have been on, they wanted me to disconnect the feeding tube and everything else. We had a very tough time making that decision.
Yep. It's a
Even though
hard job, isn't it? Making that call for a loved one.
What they offered to do was to take her out of the medically induced coma long enough for me to ask her at that point, because it had been done so long before, what I should do.
Okay.
And I said to her, do you want me to do what, you want me to do, or do you want me to do what I want to do?
Yep.
And all she could say was, I love you. And I still had to make that decision.
Yeah, that's hard. And I recommend you give your loved ones a heads up. And I tell people, you put it in writing. That's a huge plus. Now talk to them face to face.
But I knew.
And everyone's going to tell you probably, pull the plug, right? But hearing that makes a difference.
Because I knew that
Yep.
I wanted her to live, but I knew she really did not want to live that kind of life with
Right.
feeding tube and dialysis and everything else.
Okay, I saw 2 more hands. So 1, 2, and then we're going to call it. Okay, go ahead.
Can a assisted living or long-term care facility refuse to accept a patient if they don't have a DNR or a pulse executed?
Boy, that's an interesting one.
They will ask.
Can a nursing home or an assisted living reject a patient on the basis that they do not have a DNR or a pulse? Typically, they want to see a power of attorney. I haven't seen anyone insist on a pulse or a DNR. That's interesting. I'm not sure the answer to that one. I suspect if I were to research the law, the answer is no. There's no requirement that you have to have it. I know with like my wife's grandfather, he certainly didn't have one, and he was in a nursing home for a time before he passed. So no, I think the answer is probably no. They may have a policy for them, but that doesn't mean the law requires it. Yeah. Yeah, they could loosen their standards if they wanted to. I think the laws require that. Okay, last but not least. Can a religious hospital in Nevada refuse to honor a DNR? I got you. Yeah. Can a religious hospital in Nevada refuse to honor a DNR? It's happened to you? I don't know the answer to that. I have not had that come across. I suspect that the hospital does have a right to, on their principles and beliefs, to stand with them. Right? Okay, here.
In my case, this was my late husband, and they had the DNR and file. They had everything on it there, and yet they refused. They said, I didn't know what I was talking about. I had no right to say that I wanted his life to be ended because I don't know what he wanted. And that's not true, because it was very clear in the document that he'd signed more than a decade before. And it took a palliative doctor and the head of nursing to talk him out of it. And then they extubated him.
Sounds like they were giving you a hard time on other grounds, not necessarily the religious grounds. But I suspect the answer is yes. I'm not 100%. So I'd have to look into that. I have not had that happen to a client of mine yet, to have to deal with it. So sorry I'm not more helpful on that. Okay, you all stayed awake and you saved me more than one cookie. I really appreciate it. Again, I appreciate it. Thank you. If you want a copy of this, get a hold of my email. Barbara up here will have it. And then I'm here, happy to hang out for questions if you have any. Thank you very much.